It also doesn't require allegations that we're trying to investigate race-based denial of voting rights. Brad and all of these interveners are not going to win, says Civil. So for the foregoing reasons, dismiss or deny their motions to dismiss, grant us a motion to compel, force them, enter an order compelling the production of the records in response to federal law. The battle for the records in Georgia continues, and now the DOJ demanding that Brad Raffensperger, the Secretary of State out there, be compelled in order to disclose the voter rolls to the DOJ. And that, of course, is not happening because he's very obstinate and he doesn't want anybody to see what is in the files. It's time to compel him. We need an order to force Brad to disclose this material instantly. You can see they filed a motion to dismiss by interveners, motion to dismiss by the Black Voters Fund. So defendants, common cause, we got these nonprofits suing, we know what they're black voters, our privacy rights, saying, no, none of you have a basis to have this claim dismissed, and so we're asking you to dismiss all of their motions and give us the files, including the name, date, and birth as required by HAVA, the last 4 digits of the social, and all of these other things, because we're the federal government, and of course, we protect privacy rights. So this is the actual brief. They say, we're now asking you, Judge, to reject all of their attempts to dismiss this case. We're going to call all of them the defendants, but it's really everybody. Black voters, defendants, common cause, and Brad Raffensperger, who we know here well, saying the Attorney General of the United States, that's called Pam Bondi, she brought this case as part of her investigation into list maintenance practices, which are filled with illegal aliens and duplicate voters, and she has the authority to do that under HAVA, under NVRA, and we sent correspondence to Brad a long time ago asking for his cooperation, but those efforts were met by his refusal to produce the records. It's mandated by federal law, and it's necessary for us to do our job. Title III of the Civil Rights Act is the principal authority for this, grants Pam broad authority to all records, in quote, that come into possession of the election officers who govern federal elections or help facilitate elections that send candidates into the federal government. This is all unique. This is an investigative statute, and we're allowed to do this. And as discussed in detail, the record demonstrates that the U.S. has satisfied all of the requirements under the law. By contrast, these defendants have not even established a basis for their motion to dismiss. Why can't we have the files? As we're going to see, they scream about privacy rights and more. But the United States Constitution, it does invest states, Brad and Georgia, with broad powers to conduct federal elections. We know that. We covered 2020, and we're very upset about how judges stole that away from the state legislatures. But let's be clear. The election clause also has a big fat butt right there. See that right there? Gigantic butt. The Congress may at any time, by law, make or alter the regulations because you're sending candidates into federal government. States can't just say, you know what, today we're going to vote by Skittles, or all in favor, just say aye. Okay, we have elections. And if you're going to send a candidate up, the government of the federal government can monitor and investigate what you're doing. Congress enacted these broad regulations. HAVA, NVRA, they've been around forever. A lot of history about where they came from. And we invoked those. On August 14th, the DOJ sent Brad a second letter. Didn't respond to the first one. We asked for an electronic copy and a computerized list of the votes. Brad responded on December 8th. He said, what about privacy? And that he would not provide a copy of the voting records at all. Then on December 18th, the U.S. initially filed this action in Georgia. However, Georgia dismissed the case without prejudice, saying, I can't hear these cases. Brad's office is in northern Georgia. They said, fine, we'll go sue there. That's what we've done. Now, as explained in the declaration, the United States seeks these documents. We have one purpose only here. All we want to do is evaluate Georgia's compliance with the list maintenance requirements under federal law, and if appropriate, to bring an enforcement action so that they actually check their lists. HAVA requires it, and the information is necessary. We need to see, are there duplicate registrations? Have people died? Who have people moved? Do you have people on your list that are not eligible to vote in federal elections? And we know that they do. So we're entitled to these documents, saying there are elements under the law. We have met them. One of those elements is the election officer must have refused to provide the records for inspection, and they did not do that here. Now they're making duplicative arguments. All of their arguments about why this needs to be dismissed are lacking in merit. They misapprehend the claim, misunderstanding the law, and in turn, they just turn around and ignore us. And so let's explain why their motions failed. First of all, federal rules of civil procedure are inapplicable to their rules and to motions to compel under Section 305 of the CRA. A lot of technical stuff going on here. The United States cannot, though, if we interpret it that way, be expected to effectively enforce federal election laws like this if we have to have a fight over it. The Attorney General's filing of an application under this is not the commencement of an ordinary civil action, so we're not treating this as though it's like a civil lawsuit. It's federal law. It's already been decided. In structuring the statute this way, Congress has said that these civil rules are inapplicable. It's not a lawsuit. It's a request for information that Congress has already authorized. We don't need to fight it. Now, both courts that have decided otherwise in various districts, so they go to the 2 district courts, Ninth Circuit, other places, they're saying they're misinterpreting these things, and the Supreme Court has already decided a lot of this. They go back through the precedent, the Oregon case, and other cases, Powell case, showing and distinguishing those cases, and a Becker case, saying they're all being interpreted wrong, but you, or the defense here, saying that this falls under the rules of civil procedure. There sounds like there's a little bit of a split there, and they're ultimately wrong. Now, it also doesn't require allegations that we're trying to investigate race-based denial of voting rights, saying Title III of the Civil Rights Act is entitled to federal election records. It's a sweeping obligation, and you have to hold on to the documents. The language is very clear, but Brad doesn't read it. He argues that the court must ignore the actual law and find that it's limited to only a subset of the records, saying you only can go after those records that have reasonable grounds that there's something bad happening to those records. They say that's not the law at all. Congress made it very clear in the law where it intended a remedy to be limited to racial discrimination. Brad's saying you can only go investigate if there's discrimination. They say that's not the law. The law is much broader. A lot of cases interpreted it accordingly, Galleon and others. The other interveners are trying to invoke the same argument and citing mistaken case law. But when you look at it, engrafting a requirement of racial discrimination is not actually in the law. It's not only about a subset. Not only can go investigate racial discrimination, you can go investigate bad voter lists. Continuing, the Benson court decided this. And so as a result of this precedent, the U.S. respectfully submits this court decline their invitation. Don't add in another requirement that they can only go get racially discriminatory lists or something. That's not what the law says. And the CRA is pretty straightforward. All you got to do is make a written demand. We've done that. Make the demand in writing. Bondi did it. August 14th, sent a letter. After explaining why those statutes were supported, they justified their request and followed the requirements under the law. Nevertheless, Brad, he argues that they failed to provide a sufficient statement. Like, your reason's not good enough for us. Federal courts have already rejected that. You don't have to make it satisfactory to Brad or every individual secretary. It's pretty simple. AG requests it, you deliver it. They argue contrary, though. They say authority, in truth, that must be followed in this circuit has made it clear that officers of elections are prohibited from using some other maneuvers to try to dismiss this. We know you don't want to give the records up, but unfortunately for you, the law says you have to. And this is all within scope. Georgia's voter lists fall clearly within this provision of the law. In other words, we're asking for things that we can go get. Benson court read it one way. Federal courts have rejected other attempts to limit the scope of this. It's about a voter list, not only a tiny little voter list that Raffensperger wants to deliver. There is no reason to attribute a pedantic distinction to Congress. The AG is entitled, after written demand, to all records. And that's what happened here. So other courts are trying to distinguish this. They're relying on this other case called Benson. They're saying it's not even the same thing. So if you interpret it that way, this would create absurd results. This is to counteract discriminatory practices in allowing citizens to vote, but it's not the sole purpose. There's been other matters against Georgia and Texas that have been adjudicated appropriately. And so we're following the rules. You see lots of technical interpretations of kind of the various statutes, and there's no privacy concerns. The data that we're requesting here is the same that 25 states, including Georgia and DC, routinely share anyways. Private parties have been granted access to even more detailed voter lists than what we're asking for. So the United States is entitled to reproduction and copying of all these records. Now, a variety of privacy arguments are being made. They say, we have to dismiss this because you're going to see detailed and sensitive information. Now, the United States does not dispute that the requirements of the Privacy Act and all of the other things apply here, but neither statute prohibits the collection of this information on that basis. The requirement for a privacy impact panel does not apply to the investigation of list maintenance. They're going to talk about each argument under privacy. Brad says you can't get these records. He says you must comply with the Privacy Act. They say we are. But Secretary Raffensperger goes even further. He says the complaint must be dismissed because the United States never identifies a SORN in its complaint. They say that's not surprising because there is no requirement in federal law to plead in its compliance with the Privacy Act in every complaint that it brings. All we have to do is actually securely store it and prevent the dissemination, which we will. The voter information that the AG is collecting is maintained according to Privacy Act, and it's all explained in our policy. We do that. So the statutes that they cite and that we cite support what we're doing, and their arguments that this is wrecking privacy does not prohibit them or give them a basis fail to disclose the information. The E-Government Act they talk about Well, that doesn't shield them. Applying this to voting statutes would also lead to absurd results. And so Brad and all of these interveners are not going to win, says Civil. So for the foregoing reasons, dismiss or deny their motions to dismiss, grant us a motion to compel, force them, enter an order compelling the production of the records in response to federal law. Signed by the Civil Division, called Brittany E. Bennett, over to Brad Raffensperger, and the battle continues. We'll see if Brad gets the hint and starts to disclose some materials